This is Michael Popok with a Legal AF Hot Take. We finally have an ability for the special counsel to take an appeal to the 11th Circuit to capture all of the wrongful conduct and misapplication of the law and reversible error by Judge Aileen Cannon in the Mar-a-Lago case. You heard it right, folks. We finally have a decision by the judge, not a paperless order, not an extension of time, not a kicking the can down the road, an actual order. It's 14 pages. It's been docketed as document number 608, and it may go down in the annals of history as the thing that got Aileen Cannon reassigned from the case to allow the Mar-a-Lago prosecution to continue. What am I talking about? We've got an order, finally, on a series of motions to dismiss and motions to strike brought by Donald Trump, Walt Nauta, and Carlos de Oliveira. Now, the headline that you probably read is, the judge denied Donald Trump's motion as it related to an attempt to dismiss the indictment on the grounds that were stated. To summarize it, he argued in his filings, Donald Trump's filings, that the indictment was so prolix, so complicated, so including of irrelevant information that when you boil it down to the essential elements, that the special counsel missed the boat and didn't properly charge each aspect of the crime. They got the crime wrong, in other words, that the special counsel didn't properly put in the language required to support the indictment. And they go through each of the counts like that, except the judge, surprisingly, denies the motion and says most of the arguments that Donald Trump is raising are better raised at trial in front of a jury. It's not grounds to dismiss the indictment. And I was just about to get out of the room and leave and go, all right, well, still don't have an order that needs to be dismissed until I read the back half of the order, in which the judge takes on one argument of Donald Trump, but that's all you need to get to the appellate level. One wrong decision by the judge, and we now have that wrong decision. It has to do with the motion to strike a certain paragraph of the indictment, paragraph 36. I don't expect you to remember what paragraph 36 of the indictment said, so I'm going to read it to you, and then I'm going to explain why she got it wrong under Rules of Evidence 404B. The allegation, and I'll fill in the blank as to who they're referring to because we now know we can fill in those blanks, that Trump showed the PAC representative, that was Susie Wiles, who's still his political action committee representative, that does all of his bidding, who's a secret, shadowy figure behind Donald Trump, that Trump showed Susie Wiles a classified map of country B, that was Afghanistan, and told Susie Wiles that he should not be showing the map to Susie Wiles and not to get too close, indicating that he knew that this was classified information. Susie Wiles did not have a security clearance or any need to know classified information about the military operation. Okay, when we first saw that, we said, well, that goes to his intent. We always wondered why he wanted to hold on to these documents. Was it transactional? Did he want to sell them? Did he want to use them, Donald Trump, for extortion? Did he want to, extort Macron or to the prior French prime minister or president because he was having an affair? Was he going to use it in a transactional way to try to get back into office, to go after his political enemies, which he constantly says he's going to go after? Why did he keep the documents? It can't just be sloppy. I mean, that's what Donald Trump's lawyers say. Donald Trump's lawyers say their primary defense is that he didn't pack his boxes leaving the White House. They're all commingled with like his clothes and personal items and newspaper clippings and classified top secret documents, and he can't be held responsible for it, which might actually be a decent argument if there wasn't substantial evidence, including video proof and insider testimony against Donald Trump, that he got his hands up to his elbows, knee deep, to mix my metaphors, inside the boxes and reviewed each of the boxes before the lawyers for the Department of Justice met with his lawyers, Evan Corcoran and Christina Bobb. If he hadn't done that, if it was just like, well, there's some old boxes in the garage, why don't you go take a look? I don't really know what's there. I mean, that, by the way, that is a legitimate defense for Joe Biden. He did not pack up his boxes leaving the Penn Biden Center. He did not pack up his boxes and store them in the garage. He did not buy his filing cabinets. But let's leave that for another day. That is Donald Trump's sort of argument. Who knew what was in there? There's a bunch of boxes they sent. I never really got a chance to take a look at it. That's a lie, because in the indictment, there's plenty of evidence that he did take a look at it. So that's sort of their argument. And so they've argued here in the paragraph 36 motion to strike, Donald Trump's lawyers argued that that particular event, Donald Trump showing the Afghanistan map, top secret classified, to Susie Wiles, who did not have clearance, right? And acknowledging that she shouldn't get too close because he should not be showing it to her, went not to a charged crime of the indictment, but to his mental state, to his mens rea, to his intent. Now, there is a general proposition under the evidence code and under Rule 404B of the evidence code that you can't use bad other conduct to prove the indicted conduct that you're putting before the jury, unless there's an exception, which of course the judge ignored in her order giving rise to the appeal. There's an exception if you're trying to show motive and intent. We went through these issues up in New York with the Stormy Daniels New York criminal prosecution. There was plenty of evidence that wasn't an actual charged crime, one of the 34 felony counts, but went to show intent or motive. And that's why it was let in under that version, that second half of Rule 404B. It's as if Judge Cannon never read the second half of 404B. In fact, in her half a paragraph analysis of this particular section, while she takes the prosecutors to task, and I'm going to read from it in a minute, tisk, tisk, you used a speaking indictment. You should have used a boilerplate form that you got downloaded from the internet or from AI. Why are you using what's called a speaking indictment or a portable closing argument? You put so much information in there that was unnecessary to the prosecution and to the indictment. Why? Why? The same reason, I'll answer your question, Judge Cannon, the same reason that you thought at the beginning of the case when you were trying to suppress the search warrant and you were trying to set up all of these hurdles to the prosecution to even bring the indictment, you said, well, it's a special case. We have a former president. Former president needs extra protection under our criminal justice system. The reason for the speaking indictment, which is shorthand for a very long, detailed narrative that's contained within the indictment. That's not necessary legally. All you have to do is have a short, concise statement. I agree with that part of Judge Cannon's decision. But the reason is this is a public indictment of a former president, and the people have to understand the facts that have been alleged coming out of the grand jury in the indictment, right? The prosecutors, the special counsel's office realized that they were going into uncharted water, that they were going after a former president, and that in order to make their case to the American people, that this was a legitimate prosecution, they needed to put in all the detail of what they had found. They didn't have to do that, I agree. But once they did, it's obvious why they did it, and the judge should have recognized that. Well, I understand it, that they didn't download a form from the internet, right? Given that this is a very unique set of facts, they felt they needed to make an argument to the American people as to why they indicted a guy who used to be president. How hard is that to see? Suddenly, the judge has amnesia. She thought it was unique that a former president was being prosecuted and that she needed to put up safeguards and guardrails. Why doesn't she then recognize that because he is a former president, there was the need for the speaking indictment? But she takes them to task. What she says on page 13 of 14 is that having reviewed these arguments in their totality on page 13 and carefully considered the superseding indictment as a whole, the court agrees with Trump that much of the language in the superseding indictment is legally unnecessary to serve the function of an indictment as explained in the foregoing case law. The court also notes, this is her lecturing the special counsel again, the risks that can flow from a prosecutor's decision to include in a charging document an extensive narrative account of his or her view of the facts, especially in cases of significant public interest. That's the opposite. She has turned that concern upside down because there is significant public interest. She thought that the prosecutor would be able to get away with a 5-page form downloaded from the internet fill, you know what? How about that? How about that, Judge Cannon? How about they download a form from the internet and then just in every blank they just write in Donald J. Trump? How about that? Would that satisfy you? But because of the great public interest, it was required, I would submit, I would posit, that they use a detailed indictment, which she so backhandedly refers to as, and dismissively refers to as, a speaking indictment. That it was required here. That is my argument. The court also notes the risk, she continues, that can flow from the prosecutor's decision. Okay, notwithstanding these concerns, given the rigorous standard for applying this motion to strike rule, the court exercises its discretion with one exception below, not to order the striking of allegations requested by defendants, at least not at this stage. She always leaves herself a back door. It's amazing. But she continues on the bottom of page 13. The court reaches a different conclusion as to that paragraph 36 about Susie Wiles, the Afghanistan map, and Donald Trump, acknowledging that it was classified and top secret and he shouldn't be showing it to her. There, she looks at Rule 404B, but she ignores the second half of Rule 404B about motive and intent. She says that the special counsel indicates that it was included, that paragraph 36, for 404B purposes. The judge says this is not appropriate. The federal rules of criminal procedure contemplate a specific procedure governing attempts to introduce evidence of other crimes, wrongs, or acts. Federal Rule Criminal Procedure is also Evidence Code 404B. Pretrial notice must be given with supporting reasons justifying a permissible non-propensity use of the allegations. In other words, she's focused on the first half of the rule. You can't use unindicted conduct to prove that he did the indicted conduct. And we all agree with that. But you can use it in the second half of 404B, which he completely ignores, for motive and intent, to show that Donald Trump transactionally was not only harboring and hoarding all of the top secret documents that belong to the American people, but then he was using them, showing that he knew they were classified. This defeats the argument that, oh, I thought I declassified everything. I thought I mentally declassified that. I thought I did a blanket declassification, which I'm allowed to do somewhere mentally in my mind. Well, if you thought that, then why are you telling Susie Wiles that I can't show you this because it's classified? That's what it goes to. The judge continues in her wrong-headed approach over to page 14, and even then, the permissibility of 404B evidence is not always self-evident, except until trial, when the contours of defenses are crystallized and the court can assess the potential probative value and or prejudicial impact of the evidence in light of the full evidentiary picture. What she's saying is, I'm going to strike it from the pleading. I'm going to strike it from the pleading, and I'm going to reserve judgment as to whether I'm going to allow that to come in at trial after I hear more evidence or I hear more argument. So against this backdrop and without any authority provided by the special counsel authorizing the inclusion of 404B allegations in the indictment, she's going to strike it in the normal course. Then she drops a footnote. Orders granting motions to strike surplusage, which is what she says, extra stuff that shouldn't be in there, from indictments do not trigger any additional directive, nor do defendants in this case request any additional action short of dismissal. Courts have discretion to permit or not permit juries to take a copy of the indictment into the jury room. Not all juries get the indictment. And she's concerned that if she allows the indictment to go into the jury, she doesn't like that particular paragraph because it won't be balanced. I think he's got a 404B Federal Rules of Criminal Procedure appeal now to the appellate court. I think they need to give her proper direction about the 404B and motive and intent. And they might as well draw that red line right now, that line in the sand right now with Judge Cannon. They've been looking for a way to get into court, and this, I believe, is the way. So I wanted to kind of unpack that 14 pages my way, bring it to you here, and sort of show you where we're at. Now, look, there's other motions that have been filed. Donald Trump just filed a motion to suppress other evidence because he said there was spoliation. I'll do a special hot take on that one next. That has to do with, well, they didn't preserve the contents of the boxes, the FBI, when they did the execution of the search warrant, and things were spilling out, and they didn't keep the sanctity and the continuity of the boxes. We'll deal with that another time. But right now, I believe that there is a reversible error moment by Judge Cannon we've been waiting for Jack Smith to say 3 strikes, you're out. You made 2 major reversible errors at the beginning of the case. You just made another one about the application of 404B evidence in a case that goes fundamentally to defenses and to the prosecution's position on its indictment. I think it's important enough to take this appeal right now. We'll continue to follow it all right here on the MeidasTouch Network and on Legal AF. We do that show now. You know why we call it Legal AF, why we named it that 4 years ago. Every Wednesday and Saturday at 8 p.m. Eastern Time on this YouTube channel, and then on audio podcast platforms of your choice. And if you like what I'm doing like this, give me a thumbs up, leave a comment. It helps with the algorithm, keeps me on the air. It's not ego, it's algorithm. And then you can follow me on all things social media at MS Popok. Go over to the YouTube channel for the MeidasTouch Network. Free subscribe. And then go look under Michael Popok in playlists or contributors, and you'll find all my body of work just like this one. So until my next hot take, until my next Legal AF, this is Michael Popok reporting. Heary, heary, Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know and we discuss every day on Legal AF. Exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.